Welcome to The Explainer, where we break down the big topics that really matter. Sounds pretty crazy, right? But believe it or not, in the world of English contract law, just two little words, indirect and consequential, can turn into a legal minefield. And yeah, it could cost you millions if you're not paying close attention.
And here's the thing, if you get this wrong, what you thought was a safety net in your contract, it suddenly becomes a trapdoor. So what's the big deal? Well, for over a century and a half, the courts have had this, let's say, unique way of looking at these words. It's totally different from what you or I would just call plain, everyday English.
All right, so how on earth did we end up here? To really get a handle on all this confusion, we've got to jump in our time machine and head way back to the 19th century, because it all started with one single court case. A case that literally set the stage for everything that came after. Yep, that case is Hadley versus Baxendale, and you have to understand, this thing is the absolute bedrock of this whole area of law. It created this really important two-part test for figuring out what damages you can claim when a contract goes south. And that test? It's been the king of English law for over 150 years. Okay, so this case basically split losses into two buckets, or limbs, as the lawyers call them. Limb 1 is your direct loss. Think of it as the obvious stuff, right? The kind of damage that would naturally happen if someone breaks the deal. But Limb 2, that's your indirect or consequential loss. This is for the unusual things, the losses that only happen because of some special situation that, and this is key, both sides knew about when they signed. Now here's the crazy part. For decades, the courts decided that when a contract says it excludes consequential loss, it only meant that super narrow, unusual stuff from Limb 2. And let me tell you, the courts were super strict about this. For years and years, they just kept doubling down on this really narrow view, turning it into this ironclad rule. And that created a massive problem. You see, almost all the losses a business might suffer are considered direct under that first limb. So a clause that only excludes consequential loss ended up being, well, kind of useless most of the time. It just didn't offer any real protection. But, this old rule just wasn't sitting right with a lot of people. Especially as the business world got more complex, it became pretty clear that this interpretation it didn't make any sense in the real world. You could definitely see cracks starting to form in that old foundation. So top legal minds started calling it out. I mean, a major textbook flat out called the rule illogical. And when you stop and think about it, they've got a point, right? Why would two companies agree that, okay, these specific losses are recoverable only because of these special circumstances we both know about, and then, in the next breath, sign a clause to exclude those exact same losses? It doesn't add up. It's a total contradiction. And it wasn't just the academics. Even judges started raising an eyebrow. Now, they felt they had to follow the old cases, but they weren't quiet about it. They openly admitted that this traditional view was problematic. They could see it was turning these standard exclusion clauses into legal paper tigers. They looked important, but they had absolutely no teeth. So you've got this simmering debate, and it's just about to boil over. But what pushed it over the edge wasn't actually a case about this one clause. Nope. The real catalyst for change was a much bigger shift, a whole new way that English courts started to look at contracts in general. See, for a while there, if the words in a contract were a bit fuzzy, judges would often just go with whatever seemed to make the most business common sense. But then came this huge Supreme Court case, Arnold versus Britain, and it completely changed the game. The court basically laid down a new rule, literalism. They said, look, our job isn't to guess what these two parties should have agreed to. Our job is to enforce what the contract actually says. All of a sudden, the exact words on the page were more important than ever before. And this new obsession with the literal meaning of words, it set the perfect stage for a legal showdown. It paved the way for a truly groundbreaking case that was finally going to challenge that 150-year-old rule about consequential loss. So in this case, Star Polaris, the court puts this new literal approach right into practice. They don't just look at the one clause, they look at the entire contract. The builder had promised to repair any defects, and the contract made it super clear that this guarantee was in place of all other liabilities. So the court just asked a simple question. In this context, what does consequential mean in plain English? Well, it means a consequence of the failure. Simple as that. They completely ignore that old Limb 1 versus Limb 2 stuff and just went with the straightforward cause and effect meaning. And the result? Bam. All of those other knock-on financial losses, they were successfully excluded. End of story.
And you should know, Star Polaris wasn't some random one-off. Not at all. The highest courts in the land were already sending signals that these old rules were on really shaky ground. The entire legal foundation was basically shifting right under everyone's feet.
Okay, so what does all this legal drama mean for you and your next contract, right? That's the big question. Well, this shift from a predictable but, let's be honest, flawed rule to a much more flexible context is king approach, it has absolutely massive implications. All right, so here's the bottom line. This is what you really need to take away from all this. First, that old traditional rule, just forget about it. It is no longer a safe bet. Second, the natural, ordinary meaning of a word like consequential, the dictionary definition, that's what's most likely to count now. And third, and this is so, so important, just copying and pasting standard clauses from old contracts is a huge risk. A court is going to look at your specific contract, the whole thing, to figure out what you meant. So believe me, every single word matters.
Look, the legal ground is shifting, and not just in England. We're seeing this trend across the common law world. So now, more than ever, it is absolutely essential that you know exactly what your words mean before you put your name on that dotted line. Because that $1 million misunderstanding, it could be hiding right there, in plain sight.